Most people believe they would know the moment it happens, the exact second when they are no longer free to walk away. But in reality, that moment is rarely obvious. It doesn't come with a warning. It doesn't come with a dramatic announcement. And in many cases, people don't even realize it's already happened. You're standing there. Maybe it's a routine traffic stop. Maybe it's a casual conversation on the street. The officer's tone is calm, controlled, almost ordinary. And yet, legally speaking, everything has just changed. So here's a question for you. If a police officer tells you, just hang on a second, are you free to leave, or are you already being detained? Think about that for a moment. And I want you to actually answer it in your mind, or even drop your answer in the comments, because the answer is not as simple as most people think. Now, let's slowly unpack what's really happening behind the scenes, because the law that allows police to detain you is both powerful and often misunderstood. And understanding it could completely change the way you experience an encounter with law enforcement. It all begins with a concept that sits at the heart of modern policing: the difference between a voluntary interaction and a detention. On the surface, those two situations can look almost identical. An officer approaches you. They ask questions. They might request identification. They might even use a firm tone. But legally, there is a line, a very specific line. And once that line is crossed, your rights and their authority shift dramatically. A voluntary interaction is exactly what it sounds like. You are free to walk away. You are not obligated to answer questions. You are not being held by the law. But the moment an officer has legal grounds to restrict your movement, even briefly, you are no longer in a voluntary interaction. You are being detained. And that authority comes from a legal standard known as reasonable suspicion. Now, this is where things start to get interesting, because reasonable suspicion is not the same as proof. It's not the same as certainty. It's not even as strong as probable cause, which is required for an arrest. Reasonable suspicion is something less, but still powerful enough to justify temporarily restricting your freedom. It means the officer can point to specific, articulable facts that suggest you may be involved in criminal activity. Not a vague feeling, not a hunch, not a guess, but something they can clearly explain. And this idea was cemented into modern law through a landmark moment in legal history. In 1968, a case reached the highest court in the United States that would forever change the balance between individual freedom and police authority. The case involved a man named John Terry. A police officer noticed Terry and another individual repeatedly walking past a store window, peering inside and conferring with each other. To the officer, it looked like they were casing the store, preparing for a robbery. So he approached them. He questioned them. And then, without a warrant, without an arrest, he conducted a quick pat-down search. He found a weapon. The case eventually reached the Supreme Court, and the question was simple but profound. Can police stop and search someone based on suspicion alone? The answer reshaped policing. The court ruled that yes, under certain conditions, officers can briefly detain a person and perform a limited search for weapons if they have reasonable suspicion that criminal activity is afoot, and that the person may be armed and dangerous. This became known as a Terry stop, and from that moment forward, a new category of police authority was officially recognized. Not a full arrest, not a casual conversation, but something in between, a detention. Now here's where it becomes deeply relevant to everyday life. Because Terry stops and the broader concept of investigative detention happen far more often than most people realize. Traffic stops are one of the most common examples. The moment an officer pulls you over, you are not free to leave. Even if the stop feels routine, even if the officer is polite, you are legally being detained. But it goes beyond traffic stops. It can happen on the street, at an airport, in a public park, even in a shopping mall. And often it unfolds quietly. There's no dramatic declaration, no formal statement, just subtle signals. The officer positions themselves in a way that blocks your path. Their tone shifts slightly. They say something like, "Hold on," or "Stay right there." And in that moment, whether you realize it or not, your legal status has changed. You are being detained. Now here's something that many people don't fully understand. During a lawful detention, you do not have the same level of freedom as you would in a voluntary interaction. You can't simply walk away. Doing so could escalate the situation and potentially lead to further legal consequences. But at the same time, a detention is not unlimited. It must be temporary. It must be based on reasonable suspicion. And it must be related to the reason for the stop. In other words, the officer cannot detain you indefinitely. They cannot turn a brief stop into an extended interrogation without justification. And they cannot expand the scope of the detention beyond its original purpose unless new information arises. This balance is crucial because it reflects an ongoing tension between two fundamental principles: the need for public safety and the protection of individual liberty. And this tension plays out in real time every single day. Now think about this. Have you ever been in a situation where an officer asked you questions and you weren't sure whether you had to answer? This is where things become even more nuanced, because during a detention, your rights still exist, but they operate within a different framework. For example, in many jurisdictions, you may be required to provide identification under certain circumstances. But beyond that, your obligation to answer questions can vary, and this is where confusion often arises. People assume that because they are being detained, they must comply with every request, but that's not always the case. At the same time, misunderstanding the situation can lead to unnecessary conflict. So the key is awareness, understanding what a detention is, what it isn't, and how it works in practice. Now let's step deeper into the psychology of these encounters, because law is not just about rules, it's about perception, control, communication. From the officer's perspective, a detention is a tool, a way to quickly assess a situation, to prevent potential harm, to investigate suspicious behavior before it escalates. From the citizen's perspective, it can feel very different. It can feel like pressure, like uncertainty, like a loss of control, and that emotional dynamic can influence how the interaction unfolds. This is why many legal experts emphasize the importance of staying calm, composed, and aware of the situation, not because you're required to be passive, but because your behavior can shape the direction of the encounter. Now consider this. What would you do if an officer stopped you and said, "You match the description of someone we're looking for"? Would you assume you're under arrest? Would you try to leave? Would you start explaining yourself? Or would you pause and recognize that you are likely being detained under reasonable suspicion? These moments are not just legal, they are human. They involve judgment, interpretation, split-second decisions. And often, the outcome depends on how both sides navigate that interaction. Let's bring in another real-world dimension. There have been countless cases where courts have examined whether a detention was lawful, and these cases often hinge on very specific details. What did the officer observe? What did they articulate? How long did the detention last? Did the situation escalate appropriately or unnecessarily? In some cases, courts have ruled that a detention went too far, that it crossed the line into an unlawful seizure. And when that happens, the consequences can be significant. Evidence may be excluded, charges may be dismissed, and the entire case can unravel. This is why the standard of reasonable suspicion is so important. It's not just a formality, it's a safeguard, a requirement that forces officers to justify their actions based on observable facts, not assumptions. Now here's another layer to consider. Not all detentions look the same. Some are brief and straightforward. Others become more complex. An officer might initially stop someone for a minor reason, and then, through observation or conversation, develop additional suspicion. At that point, the scope of the detention can expand, but it must still remain grounded in legal justification. And this is where things can become unpredictable. Because human behavior is unpredictable, people react differently under stress. Officers interpret situations differently based on their training and experience. And the law, while structured, must adapt to these real-world dynamics. Now pause for a second and think about your own experiences. Have you ever witnessed a police stop, maybe from a distance, maybe involving someone you know? Did it seem clear what was happening, or did it feel ambiguous, uncertain? That ambiguity is part of what makes this topic so important, because the law that allows police to detain you operates in that gray space between freedom and control. It's not always visible, it's not always announced, but it's always there, and understanding it gives you something incredibly valuable. Clarity, not just about your rights, but about the situation itself. And clarity changes how you respond. It changes how you interpret what's happening. It reduces confusion, and in many cases, it prevents escalation. Now, as we move toward the bigger picture, there's something else worth reflecting on. This law is not just about individual encounters. It's about the broader relationship between citizens and law enforcement. It's about trust, accountability, and the ongoing effort to balance authority with freedom. Because every detention, no matter how brief, represents a moment where that balance is tested, a moment where the power of the state meets the rights of the individual, and how that moment is handled matters. So the next time you see an officer approach someone, or the next time you find yourself in that situation, ask yourself this: is this a voluntary interaction or a detention? What has changed? What does the law actually allow in this moment? Because the answer to those questions can reshape everything that follows. And as we've seen, the law that allows police to detain you is not just a rule written in a legal textbook, it's a living principle, one that plays out in real time, in everyday situations, often without announcement or explanation. It is grounded in the idea of reasonable suspicion. shaped by decades of legal precedent and constantly tested in the real world. Understanding it doesn't mean challenging authority. It doesn't mean creating conflict. It means recognizing the structure of the moment you're in and responding with awareness, not uncertainty. Because in that quiet, often unnoticed shift from freedom to detention, knowledge becomes your greatest advantage. And now I want to hear from you. Have you ever been in a situation where you weren't sure if you were being detained? What did you do? How did it feel? Share your experience, because these real-world stories reveal something no legal definition ever fully can: what it actually feels like when the law moves from theory into your life. And that, more than anything, is where understanding truly begins.